All right, good afternoon, everyone, and welcome to today's webinar. My name is Jorge Acosta Palmer, and I'm the director of the Statewide Training Initiative with Florida Legal Services. We're excited to have you join us today for the fourth and final segment of our Strategic Advocacy Across Courts, Agencies, and Legislature CLE series. This segment is Comprehensive Strategies to Effectuate Change. So before I introduce our speakers, I do want to go through some quick housekeeping announcements as usual. This training is being recorded, so if you register, you're going to receive a copy of this recording via Zoom, with an email from Zoom within about 24 hours. We will also be posting it on YouTube, so that usually shows up in probably this afternoon. It will be available. So make sure to subscribe and like our page. That way you get notified immediately. But if you were unable to register or you know of somebody who was unable to register, feel free to share these links. In the email, I will also include a link to the series page. It will take you to the PILS website, but we will have all four sessions posted in there, so it's easy to find all four segments in one place. So this training was approved by the Florida Bar for one general CLE credit, one state and federal government admin and admin practice certification credit, point 0.5 professionalism credit, and point 0.5 ethics credit. This was like everybody gets CLE credits, right? So really important note about this entire series. Today is the fourth and final segment. If you watch all four segments, if you really look at it, you're gonna get a
Yeah.
bunch of CLEs. You get four CLEs general, you get four state and federal government and admin practice certification credit. One of our sessions has one appellate certification credit, and as a whole, you would get two professionalism credits and two ethics
Mhm.
credits. Those are usually really hard to find, so
Yes.
it's kind of a great bundle, and to get all these CLEs as part of one series. So thank you, Viletta, for all the work that you put in and making sure that we got credits for every single category. So closed captions are enabled for anybody who needs them. If you're having any issues with accessibility or the captions, you can reach out to me directly. Quick comment about the CLE. I just wanted to mention it. I'll drop the CLE code in the chat at the end of the webinar. I know Violetta has been adding the CLE codes in the slides at the end as well. So also be on the lookout on the YouTube description. I always make sure to add a link to the materials and the CLE code as well to make it a little bit easier. You will see this via email from Zoom as well. Now, this training is being co-hosted by the Public Interest Law section of the Florida Bar, or PILS, and the Admin Law section of the Florida Bar, ALS. So this is like the fourth time I've said this, but I don't get tired of this joke. But I guess we're pals, right? PILS and ALS, we're pals. So I'm going to drop a
Yes.
lot of links in the chat for both sections. Please check out both sections, their membership benefits. I will also include social media accounts. So please follow the social media accounts, like or subscribe if it's an option. So something that I wanted to put out there. And final piece of housekeeping announcements are questions and answers. We're going to ask the audience to hold their questions towards the end. At the end, you can use the Q&A feature. And you can also use the chat, but the Q&A feature is a little bit easier to monitor. Be on the lookout because the slides do include a poll at some point, so it's gonna be interactive. So be on the lookout for that poll so you can participate and answer. So with all that said, I'm gonna go ahead and introduce our speakers today. Our first speaker is Don Winstead. Don is a health and human services policy consultant with more than 40 years of state and federal experience, a former deputy secretary of the Florida DCF and deputy assistant secretary at the U.S. Department of Health and Human Services. He has led major child welfare and anti-poverty policy initiatives and now advises governments and organizations nationwide. Our other speaker and recurring speaker is Viletta Coombs. Viletta is a Florida bar attorney with more than 20 years of experience in administrative, legislative, and litigation advocacy. She has dedicated much of her career to public interest work with Florida Legal Services and multiple Florida state agencies, focusing on serving vulnerable children and families. Ms. Coombs is also an experienced trainer, presenter, and leadership development professional. So, with all that said, it's my pleasure to pass it over to our speakers, Violetta and Don. The floor is yours.
Thank you so much. Thank you. And thank you for joining us for the strategic advocacy across courts, agencies, and the legislature. As you see, presenting today, myself, Viletta Coombs, with Don Winstead. And a special thank you to the Florida Legal Services Statewide Training Initiative, the Administrative Law Section, and the Public Interest Law Section of the Florida Bar for sponsoring this CLE series. Before we begin, I'd like to provide the following disclaimer. The content of the CLE, as well as the views and opinions expressed by the CLE presenters, do not reflect the views of current nor former employers, including but not limited to Florida State University, Florida courts, Florida agencies, and the Florida Bar. The presenters' views are their own and not legal advice. The presentation of this information does not form an attorney-client relationship. This information is for educational purposes only. Let's begin segment 4, comprehensive strategies to effectuate change. We're going to talk about direct representation versus impact work. The following case study is based on factual events between 2010 and 2011. Factual events pertain to the unemployment compensation appeal with the Unemployment Appeals Commission, now known as the Reemployment Assistance Appeals Commission, the amicus brief, the Supplemental Nutrition Assistance Program utility allowance, and everything thereafter. For the purposes of the case study, this incident takes place in Marshland, a fictitious state that follows Florida law and mirrors Florida's system of government, executive, legislative, and judicial. Here's our case study. Following the incident with Mandy Magpie, Patty the Python, and student injuries resulting from the stampede of students in the hallway, Mr. Swamps was suspended from his teaching position at Marshland Academy. Shortly thereafter, he was terminated from his teaching position. And by the way, Patty the Python was the principal's pet. Mr. Swamps had no control over Patty being assigned to his classroom. Mr. Swamps timely filed a claim for reemployment assistance benefits, formerly known as unemployment compensation benefits. His claim was denied. The appeals referee denied his claim. The Reemployment Assistance Appeals Commission issued a final order upholding the denial of benefits. And then Mr. Swamps, a resident of Bog County, Marshland, timely filed an appeal with the Marshland Second District Court of Appeal. The second DCA transferred Mr. Swamps' appeal to the first DCA. You represent Mr. Swamps. In his appeal to the second DCA, you don't understand why the second DCA transferred the appeal to the first DCA. You review the statute 443.1514E. And remember, we're in 2010. Judicial review. Orders of the commission entered under paragraph C are subject to review only by notice of appeal in the District Court of Appeal in the appellate district in which the issues involved were decided by an appeals referee. This is the most important part of the statute for the purposes of our discussion today. We're doing impact work. We're doing systemic change. As you review the statute, the case law, and public records requests, you begin to understand that there are conflicting DCA opinions regarding the proper forum for RAC appeals, as discussed in segments 2 and 3 of the CLE series. There's an issue with the second DCA's application of 440 Florida statutes to Chapter 443 Florida statutes, as discussed in segment 3. The forum for RAC appeals impacts Mr. Swamps as well as all unemployment claimants. So this is an unintentional test case, as discussed in segment 2. Remember your advocacy strategy as discussed in segments 1, 2, and 3 of the series. First, identify the issue. Second, develop the legal strategy using administrative, legislative, or litigation advocacy or a combination thereof. If needed, identify the perfect client to pursue the issue. In other words, be strategic in choosing the right person, the right entity, etc., with beneficial facts, location, timing, etc. And lastly, impact. The outcome impacts all people or entities with that issue. So as you're looking at Mr. Swamp's case, you realize this is not direct client representation. This is actually impact work, because this case will create precedent that will impact all RAC appeals. This is a systemic issue, and the outcome has the potential to result in systemic change. At this time, we're going to take our ethics poll. Here's your question. You realize Mr. Swamp's case is an unintentional test case that has the potential to impact all unemployment claimants. Marshland Legal Services, MLS, contacts your office about filing an amicus brief in this matter. And what is your ethical duty? 1, you communicate with MLS without Mr. Swamp's permission. 2, you inform Mr. Swamps that his claim is a test case that impacts all unemployment claimants. And you inform Mr. Swamps that MLS has contacted you about their desire to file an amicus brief on behalf of the Marshland Workers Center. You proceed as advised by Mr. Swamps. Or 3, you tell Mr. Swamps that MLS is a well-respected organization that the Marshland Supreme Court tends to favor. It would be in Mr. Swamp's best interest to approve the MLS brief to support his claim and garner favor with the Marshland Supreme Court. Or 4, Mr. Swamps authorizes you to communicate with MLS. You get busy with other cases and forget to respond to MLS. You advise Mr. Swamps not to involve MLS in this matter. At this time, will you please select your answer using the poll? And we'll give that a moment.
Give it a
Jorge,
few more seconds. We have 48.
okay,
Oh, we are 50% participation.
okay.
So I guess we'll give everybody 5, 4, 3, 2, 1, and I'm ending the poll. Let's see and share the results. We had 54% participate, and
Okay.
it seems like option number 2 was the most popular one.
All right, let's go through them one by one. You communicate with MLS without Mr. Swamps. Congratulations to everyone for not selecting this answer, because that would be misconduct and you're providing confidential information without permission. 2 is the correct answer. You're communicating with your client, you're informing your client about the pros and cons of what they do, and then you're proceeding as advised by your client, not yourself. Now let's go to 3. 3 is tricky, but it's actually the wrong answer and would be considered misconduct because you can't engage in conduct in connection with the practice of law that is prejudicial to the administration of justice, and you cannot imply an ability to improperly influence a government agency or official or achieve results by means that violate the rules of professional conduct. That's why 3 is wrong, because in 3, Mr. Swamps is, essentially saying, I believe we're going to win because MLS is so well respected and somehow they have sway with the court. It's not a truthful, accurate statement, and it's a violation to advise your client in that manner. And thank you everyone for not selecting answer 4. You have to communicate with your client. I know we get busy and things happen and work is working and life is lifing, but we still have to actively communicate with our clients, and we have to follow through with what we've been advised to do by our clients. So thank you for participating in the poll. We'll continue now. So we're in part 3, the power of the amicus brief. And we're talking about third-party participation now. You represent Mr. Swamps. You do not represent all unemployment claimants. In fact, representing the needs of other unemployment claimants may be outside the scope of your contractual and professional obligations to Mr. Swamps. You explain the gravity and impact of Mr. Swamp's case to him, and then with permission, you respond to Marshland Legal Services, MLS, and their inquiry about filing an amicus brief. And you and MLS agree that it's prudent for MLS to file an amicus brief in your appeal to the Marshland Supreme Court. The amicus brief. In Latin, amicus curiae literally means friend of the court. Amicus generally refers or references persons or an entity that is not a party to the matter, but has a strong interest in the matter. This party may petition the court for permission to submit a brief in the matter, specifically an amicus brief. Sometimes the appellate court allows the amicus curiae to participate in oral arguments. Courts also use the amicus brief to aid in their decision-making and cite to them in published opinions. Let's look at that legal authority to do this. Under the federal rules, Rule 37 of the Rules of the Supreme Court of the United States, it dictates the content, format, and circumstances of the amicus brief before the U.S. Supreme Court. And in general, Rule 29 of the Federal Rules of Appellate Procedure govern amicus curiae in federal court. Now let's look at state. In Marshland, an amicus brief is governed by the Florida Rule of Appellate Procedure 9.370, amicus curiae. In the sub A, it says, when permitted, a amicus curiae may file a brief only by leave of court. A motion for leave to file must state the movement's interest, the particular issue to be addressed, how the movement can assist the court in the disposition of the case, and whether all parties consent to the filing of the amicus brief. There's more, but this is the pertinent portion for our discussion. Let's look at the application of the law. The amicus gives the filing party access to the space in which the issue resides within the statute, the rules, the state agency tasked with administering the federal unemployment insurance program, and the court. The amicus serves as a pathway to inform the court about how the subject matter impacts other parties. You want to provide additional data and insights and make credible arguments to persuade the court. The amicus also serves as a means to communicate your position, concern, and reasoning to the opposing party. Every filing, message, and conversation is an opportunity to educate a person, party, court, etc. about the subject matter and the intentional and unintentional consequences involved in the outcome of the court's decision-making. So let's look at the amicus in Mr. Swamp's case. In this instance, the state agency has the ability to work hand in hand with MLS to seek amendments to the statute. So it's one of those rare, though cherished moments where the adversarial parties can work together and inform the Marshland legislature that the agency is not at fault. You don't hear that a lot, but it does happen. The agency is not at fault. The agency no longer conducts hearings in person in brick and mortar. The statute needs to be updated to include the agency's current practices, policies, and procedures. Mr. Swamps and the agency need a legislative fix. They need a legislative remedy. In this instance, the Marshland legislature agreed and updated the statute as discussed in segment 3, which relevant part says, orders of the commission entered under paragraph C are subject to review only by notice of appeal in the District Court of Appeal in the appellate district in which a claimant resides, or the job separation arose, or the appellate district where the order was issued. Let's go back to that slide. This is the update of the statute to reflect current practices, policies, and procedures. And it's a really good day when the court looked at the legislative intent. The legislature looked at the legislative intent to realize that limiting it to the appeals referee district was not what the statute was meant to do. It made sense when we were there in person in brick and mortar, but now that things are being done by phone, that appeals referee could be anywhere. Also consider we're actually living through this right now where we're doing fewer and fewer things in our practice of law in person. Aside from our trainings on Zoom, our meetings on Teams, even in our interaction with the court, many of our hearings are on Zoom. So we're going to see updated legislation to address statutes and rules to address our virtual process communications, hearings, and AI. So sometimes a statute, a rule does need to be updated. Now let's talk about discrete issues that have a broader impact. Mr. Swamp's life and his livelihood are going an ongoing state of flux. He lost his dream job of teaching at Marshland Academy. He is struggling to find employment. While his unemployment compensation appeal is pending before the Marshland Supreme Court, Mr. Swamps needs assistance with supporting his family. So Mr. Swamps applied for public assistance, and his household income, specifically his wife's income, was deemed too high to qualify for benefits. So you contact MLS because MLS specializes in public interest law. Let's talk about our Supplemental Nutrition Assistance Program, SNAP, formerly known as Food Stamp Program. SNAP is a federally funded nutritional assistance program administered by the Marshland Department of Social Services, MDSS. This program is a means-tested program that uses income deductions to reduce the gross income to determine the net income to determine eligibility for the program and the benefit allotment under the program. Now, let's talk about the utility allowance. This is our very discrete issue. One of the income deductions is the utility allowance. As it turns out, MDSS had not adjusted the utility allowance for Marshland in 9 years. Marshland's utility allowance was not comparable to the utility allowance in California, a similar warm weather state. To put this into perspective, Marshland's utility allowance was a 2-digit number, while California's was a 3-digit number. Also of note, there were approximately 4 people at MDSS that determined Marshland's utility allowance. Remember, the utility allowance is a deduction that references how much you may pay for utilities and taking that into consideration when determining your household income. So you're looking at this issue because a client doesn't come to you with one issue, they come to you with many, and you just do the best you can to try to address the main and the others to the extent that you can. So here, the utility allowance is really low, and you think and you know it'd be a great idea to update it. So you and MLS, you contact MDSS, that's the Social Services Agency, regarding updating Marshland's utility allowance to be consistent with another warm weather state such as California. You present a utility allowance analysis that an expert completed for Marshland, by the way, at no cost. And you explain the expert's utility allowance analysis for Iowa and Wisconsin were accepted by Food Nutrition Services, FNS. And you're confident that the expert's analysis for Marshland will be accepted by FNS as well. So the MDSS attorney was not persuaded by your presentation and said, I don't know how they do things in Iowa or Wisconsin. I know how we do things here in Marshland. Having put on your listening ears, let me repeat, having put on your listening ears, you decide to launch a statewide campaign with a sign-on letter asking MDSS to increase the Marshland utility allowance to be comparable to another warm weather state such as California. Remember, we're comparing apples to apples at this point. The sign-on letter further explains that increasing the utility allowance will increase eligibility to qualify for SNAP and increase the benefit allotment under SNAP. So last but not least, SNAP was a federally funded public assistance program that it does not require any state matching dollars. Therefore, an increase in the eligibility for the program and the benefit allotment under the program will literally bring more federal dollars into the state of Marshland to provide a basic human need, specifically access to food for children and families. You circle back to the MDSS attorney and you present your sign-on letter that is endorsed by numerous attorneys, special interest groups, a statewide food bank, a utility signed on, and others. Then you disclose that your utility expert graduated from Marshland University. And now that you've hometowned your expert, you ask the MDSS attorney to increase the utility allowance. About a week later, the MDSS attorney informs you that Marshland's utility allowance has been increased using an internal analysis to reach the new dollar amount. And guess what? You don't care what analysis MDSS used because the updated utility allowance is comparable to California. This is a win. This is a discrete issue of increasing that utility allowance that impacts hundreds of thousands of low-income Marshlandians by increasing their eligibility to qualify for SNAP and their benefit allotment under SNAP to provide a basic human need, food for children and families. This is what impact work looks like. This is systemic change. This is what I did when I was with Florida Legal Services. I do have an update. Historically, the Supplemental Nutrition Assistance Program benefits have been 100% federally funded, while administrative costs are split about 50-50 with states. However, in the One Big Beautiful Bill of 2025, it introduced state matching requirements for benefits and reduced the federal share of administrative costs, ending the program's entirely federally funding model, notes the Georgetown Center on Poverty and Inequality. So this has changed. However, the process of what we did, it hasn't. You can find that discrete issue and have an enormous impact on hundreds of thousands of people. Now I'm going to transfer the presentation to my co-presenter. Thank you so much, Don Winstead.
Great. Thank you so much, Vi. I appreciate the opportunity to be with you all and to share some information with you. So next slide.
The value of adversarial collaboration.
So first of all, some barriers to collaboration. Now, I'm not an attorney. I'm probably the only one on this call who's not an attorney. But my experience as an administrator is that opposing counsels tend to perceive collaboration as unnatural and in conflict with their respective advocacy obligations. Agencies may operate in crisis mode where they're constantly bombarded with multiple issues that are equally important and simultaneously failing. It's a recipe for disaster in which the agency is perpetually bailing water from a sinking ship. The agency is focused on how to survive. The agency is not thinking about how to collaborate with the folks that put the holes in the ship. There's a proactive versus reactive element that you need to consider. In agencies, there's a tendency to be reactive, and it comes out of that crisis way of operating. I often, when I visit agencies today, even though I spent most of my career working in public agencies, it is so easy to forget how completely hectic the environment is. And so responding to the crisis takes priority over planning, prevention, and improvement. So the solutions, first of all, change the conversation in real time, help the agency or the opposing party understand that the crisis has already occurred, and this is the rebuilding stage. It's an opportunity to be proactive with planning, prevention, and improvement. So I'm going to give three examples from my experience in working in Florida and in the federal government, I should say in marshland, in the federal government, and experiences that I have encountered. The first we'll call the open door policy, establishing lines of communication. In this situation, I was director of the public assistance programs in marshland. And I one day looked up and at my framing the door was our legal counsel with not a happy look on his face. And he said, Don, I need you to go to Miami and I need you to go to Miami and be very contrite and stand before a federal judge. And I said, what's the problem? And he says, well, down there, we're out of compliance with the timeliness standards. The local district is not processing, and this was prior to SNAP, this was under the food stamp program, food stamp applications in a timely manner. Legal Services has taken us to federal court on this issue. We have told the federal court that we would fix it. We have failed to do that. And now we have a show cause order to go back before the federal judge and explain ourselves. And I said, well, okay. And I made a joke about, going to do that. And he looked at me and he didn't smile again. He says, Don, bring your toothbrush. And I went, ooh. I said, well, tell you what, before we go to before the federal judge, can you arrange a meeting with the plaintiffs and let me meet with them? He says, they won't meet with you. It won't do any good. We've had those meetings before. And I said, no, I'm not. I haven't been part of those meetings. Let me meet with them. And if we don't succeed, okay, we go see the judge. And so we met with the plaintiffs and the district folks and their legal counsel were there. And I was there with our assistant general counsel. And I said, look, we're guilty. You know it, and I know it. Well, at that point, our attorneys just about fell out of their chairs. Like, you can't say that. But I said, look, you know it, and I know it. There's a requirement. We failed to meet it. We've said we're going to meet it, and we failed to live up to that commitment. Will you give us one more chance? Will you give me a chance to fix it? And although they could have very easily taken us into federal court and notched a win very easily, they said, okay. And they gave us a chance to fix it. And we did fix it. And we fixed it much more quickly than had we gone through another legal process to get to the same result. So that was a case by extending, having lines of communication and at least building a little trust. We were able to receive a result, and the plaintiffs were able to achieve the result that they were looking for in this particular situation. The next case, a careful referral. And this goes back, this is even a little bit earlier in time when I was early in my career as a supervisor in the relatively early days of the food stamp program. And as a supervisor in the program, at this time, today everything's done electronically and online, and you don't have really offices all around the state like you used to. But in these early days, there were food stamp offices out all throughout communities in Florida. And in my office, which was in the southwest part of Jacksonville, each of the legal services office in the area, each had attorneys or paralegals assigned to each office to take care of any appeals that came out of that. And in those days and today, I guess if a decision is made and you disagree, you can file for a fair hearing before a hearing officer. And I had observed in watching some of my colleagues that the process and adversarial process of the agency and the client going to this hearing was really not a very efficient process, and a lot of times could be resolved or should have been resolved before getting to that point. So I met with the paralegal who happened to have the lead in terms of monitoring our office. And I said, listen, if you find a situation where you're going to request a fair hearing, will you at least meet with me first? And let's talk about it. Give me a chance to resolve it. If I can resolve it, fine. If I can't resolve it, then we can go have the hearing. And she said, okay. And we went on that basis for a number of months and were largely able to resolve the situations. Well, then we had a case where the client happened to be the assistant manager at Marshland Mini Mart. Okay. And at those early days in the food stamp program, there was a federal law or federal policy regulation that said if someone was the manager or assistant manager in a retail store that was authorized to accept food stamps, then they were ineligible to participate in the food stamp program. So this person was the assistant manager. He was financially eligible, and the only reason he was designated really as an assistant manager was so that Marshland Mini Mart could get by without paying him overtime. So he was the guy that worked at night in the store, but they called him the assistant manager. But technically, he was ineligible for food stamps. And one of my workers came to me and said, "Okay, here's the deal. We've denied him, but this just doesn't seem right." And I looked at the case. I said, "You're correct." So I talked with the gentleman, and I said, you could file an appeal, and you're not going to win it, but there may be more than you could do. Tell you what, here, how about if I give you the telephone number of this paralegal who works with folks in our office, and maybe she can help you. And so he called her, and they represented him and lost the fair hearing because it was clearly under policy, but then appealed. And the appeal went to the federal district court. And while it was being appealed, there was a similar case that got resolved in the federal court. The bottom line was that policy was determined to be unconstitutional in federal court, and the person won their appeal and was able to get benefits for the family. So that was a situation where we could have very easily said, "Hey, policy's policy. That's the law," and won the case. But that would not have been a fair or equitable result. And we're able to work collaboratively to at least steer the person in the right direction to get some help with their situation. The third, working together, and this one came to mind because it reminds me a little bit of the of what Viletta went through with the marshland utility SNAP utility allowance situation. And this again goes back a ways. And if you remember today for public assistance benefits in Florida is called TANF, or the Temporary Assistance for Needy Families Program. Before TANF, there was a program called AFDC, Aid to Families with Dependent Children. And this goes back to the AFDC days. And as part of AFDC policy, each state had to establish what was called a consolidated need standard. And this was, in theory, the minimum financial need that a person had to have. And it wasn't the final determination of the amount of benefits you got, but it was a step in a multi-step process to determine eligibility. And the consolidated need standard in Florida was very low. And legal services brought suit against the state and said this is unacceptably low, it's unreasonably low. And like with the utility allowance case, they brought forth information from economists and various sources to say how Florida was so very, very low and that it should be increased. And over a lot of back and forth and haggling, ultimately we determined that we did not have a winning hand, okay, and we agreed that it was unreasonably low, And we determined that because it wasn't the final benefit amount, which had to be set by the legislature, that we could, without changing the law, we could agree to settle the case. And we said, okay, so what do you think it ought to be? And legal services said, we think it ought to be the federal poverty level. And we said, oh, okay. And so ultimately the case was settled. Well, at the time, the consolidated needs standard was about $400. And after we settled it, the poverty level was a bit over $800. So it more than doubled. And under the settlement, we agreed that it would continue to grow as adjusted by inflation over time. So by the time the AFDC program was eliminated in 1996, when TANF was created, it had grown to $1,082 a month. Well, serendipity, because at that time, and something that nobody could have foreseen, Congress, in their wisdom, decided to establish the financial eligibility threshold for Title 4E child welfare funds. That's the federal funds that pay the federal share for foster care, to establish that as the old AFDC consolidated needs standard as in place when the new law passed. So rather than having a consolidated needs standard of $400, it was $1,082. And that has continued now for 30 years. And I did a quick calculation. Florida has received very likely hundreds of millions of dollars in federal funds because of agreeing to that change in the consolidated needs standard. Hundreds of millions of dollars in funds for child welfare, for the foster care and adoption program that would not have been received. So again, one where we were able to work something out. In this case, not only was there a potential benefit immediately, but there were downstream benefits that we never could have anticipated in working through things in Florida. So those are at least some examples of situations where we've had some adversarial collaboration and have been able to work out situations. In one situation, legal services clearly could have won and chose to go a different path and work out a compromise. A second one, the agency clearly could have won, and we helped get a positive result. And the third one, we all won without even knowing it as we went forward. So those are at least some examples of situations that I've seen in my time in working sometimes adversarially and sometimes collaboratively with legal services over the years.
Don, before you close, do you have any final thoughts?
No, I think clearly the key message I would have is that although the relationship between agencies and people representing the clients who are affected by those agencies, whether that's legal services or private attorneys or whatever, while there is naturally an adversarial feel to that relationship, the key point is to understand when we share a client, we both have a responsibility to that client to further their needs where we can. And sometimes the law is going to be constructed such that we have a duty to follow the law, and we're going to have to let the courts work it out. But many times, if we can find a way to achieve a positive result for our mutual client, then they're going to benefit, we're going to benefit, and the system is going to improve.
Thank you so much for sharing your final thoughts. It's extremely helpful. It's so helpful to hear from you. A lot of people think it's an oxymoron to say adversarial collaboration. But you have shared the factual stories about how it absolutely can work, where you're still maintaining your professional responsibility to your client, whether you're the attorney or the agency that's providing a program that's federally funded or state funded. You all have a goal. And if you communicate and share information with one another, there actually is a likelihood that you can reach your goal. So thank you again. All right, we are doing great on time.
We are. So I don't see any pending questions in the chat, and this is the time if you're attending, you want to use the Q&A for questions. Let me take a quick look. I do not see any questions pending in the Q&A, but feel free to drop them while we wait for questions to come in. I'm going to go ahead and drop the CLE code and the link for the materials. I just dropped it into the chat. The CLE code is 2600951 and N, but let me read it again. 2600951N as in Nancy. So I dropped the link to the materials as well. You will receive an email from Zoom that has all this information. If you look at the YouTube videos, when I post them, if you open up the description and you uncollapse it, you will find the link to the materials. You will also find the CLE code as well. I will also drop the link to the series page. Obviously, this one is not posted yet, but I will have all the sessions posted in one page if it makes it easier for you to access, but also easier for you to share with others. Make sure to bookmark that link and to keep it as part of your advocacy toolkit. So let's see if we have any questions. I did see a few reactions, applauses, and thank yous come in. So always love seeing those. Let's see. I don't
While we're
see.
waiting for questions, I will share one thing in my practice of law. I have always been non-adversarial without compromising my obligation to my client. And some attorneys have just not known how to respond to it because I focus on the law, what's needed, and what we're trying to do. Throughout the series, you will see a theme of not just adversarial collaboration opportunities and what they look like and how you can make a huge impact, but also a theme about communication. Don didn't have to try to communicate with the legal services office, and they certainly didn't have to communicate with him. But they did communicate, and look at what happened. Think about your opportunities to communicate. Even if you are in a deposition with your opposing counsel and the witness, this is also your opportunity to communicate to them what's happening with the case. Usually you'll do it in the form of the types of questions that you ask. But the point I'm making is that if you have opposing counsel and you're deposing, their client, this is the first time that person's heard from you. They've only heard the voice of their attorney. They haven't been given necessarily information about how things are going on the other side of the street. You also, in this moment, have the ability to educate them about things that they may not know about or been given any perspective of or just any useful information about. Use your interactions with your adversaries as an opportunity to learn about what's needed, what's happening on the other side of the street that you don't know about. Because when you get the devil in the details, so to speak, it puts you in a better position to try to address and accomplish and meet your goals. And it's hard to do if you actually don't know what the barriers are.
Yeah, I think too, that's such an important point, Viletta, because one of the things to keep in mind as you have those interactions, and back to the point we made about the chaotic and frenetic environment that that state agencies often exist within, when I was an administrator, first of all, if things were going well, that never came to my attention. Okay. So I disproportionately, my attention was drawn to things that were not going well. And if I was being deposed, then two things were happening. Before the deposition, I would be sitting down with our attorneys going through in detail what the issues I was likely to be deposed about are. So that might be the first time that I really had a chance to focus on the issue. So, and sometimes in that time, I would say, well, wait a minute, why are we taking this position? Or why are we taking that position? Why haven't we tried this? Why haven't we tried that? So it really is a way of focusing attention on the issue, even before the deposition, as well as in deposition. You learn things and you learn perspective. Uh, Now, I always had to be careful. Remember one time I was being deposed, and it was a case where the Attorney General's office was representing us, and the Attorney General, as we were going through the deposition, she kind of, after a little while, she called a timeout, said, "Can we take a short break?" We went outside, and she said, "Have you ever been a teacher?" And I said, "Yes." And she said, "It shows. Stop it." So, and so, you have multiple parts of the relationships, but certainly the more communication that occurs, the better.
Absolutely.
Right, so I'm
Well,
looking at the chat. I don't see any pending questions. I know we're a little bit early on time, so I just wanted to take this opportunity and take a moment to thank everybody that joined, not only today, but joined us for our previous segments. I also want to thank everybody that made this series possible. A huge thank you to all of our speakers, including Don. We've had other amazing speakers and across all four sections. Your time, expertise, thoughtful engagement made this such an amazing and meaningful series. We were fortunate enough to have judges, practitioners, and advocates who not only brought their knowledge, but also like real commitment and examples and experience and stories, and all that all lead to advancing strategic and ethical advocacy. So, on behalf of the Florida Legal Services Statewide Training Initiative and the Public Interest Law section, I also want to thank our partners at the Admin Law section of the Florida Bar for collaborating with us and bringing the series to a statewide audience. Make sure to look at both sites, look at both sections. In particular, sometimes there are committees that deal with these type of issues. I know with pills, we have the Advocacy Committee led by Janine Rice and Caitlin Cliven. We recently had a really productive meeting where we were discussing a lot of ideas and systemic issues and figuring out ways on how to approach them. So consider joining both our sections. So I kind of left Viletta as the last person that I wanted to thank because she really deserves a very special and well-deserved thank you. Viletta was truly the mastermind behind this entire series. I still remember when I got that email from Janine Rice introducing me to Viletta, and Viletta shared her outline. I was like, oh my God, I'm going to do whatever it takes to put this together because it looks amazing. Viletta and I were talking about all the work that goes behind the scenes with putting a series like this together. Viletta, how long did you say this has been being worked on and planned?
this one was actually a year in the making, because as much as I had my outline and my thought process, as I began to discuss with my co-presenters, it really helped me to reform and revise and really shape the discussion even more. So I truly benefit from the opportunity to collaborate with all of my co-presenters. And just thank you, Jorge, for everything that you've done to help with this. I sincerely appreciate it. Thank you to the Public Interest Law section, the Administrative Law section. Thank you so much for co-sponsoring in the Florida Legal Services Statewide Training Initiative. I sincerely appreciate it, and I'm so glad that this came to fruition and we had the opportunity to present all of this information.
All right. Thank you, Valletta, and thank you everybody that joined us. So thank you everybody for being part of the series, and we hope to see you at future trainings. Have a great rest of your day, everybody. Thank you.